A lot of this course is about the common law and ordinary legislation, meaning statutes enacted by legislatures. But most modern legal systems, including the legal systems of the United States, also have constitutions. In the final unit of the course, we're going to examine a few topics concerning constitutions, beginning today with philosophical issues surrounding constitutional interpretation. In legal systems without constitutions, statutes are the supreme source of law. Other systems have written constitutions that are superior to statutes. As new governments are formed around the world, many are adopting written constitutions. Constitutions are like statutes in some respects. Both are codified sources of law, unlike doctrines of the common law, the authoritative statements of which are found in published court opinions. Constitutions, like statutes, have an explicit authoritative text. The text of a constitution contains a definite set of rules, principles, and standards. Constitutions are organized into articles and amendments, which in turn consist of provisions and clauses. The main difference between constitutions and statutes is that constitutions are higher-order sources of law. This is a defining feature of a constitution. The federal Constitution of the USA is superior to federal and state legislation. State constitutions are superior to state legislation, but not to federal statutes. Constitutions establish branches of government and lawmaking procedures. They also include limits on the content of law and limits on government. Section 117 of the Australian Constitution provides that a subject of the Queen, resident in any state, shall not be subject in any other state to any disability or discrimination which would not be equally applicable to him if he were a subject of the Queen resident in such other state. Imagine that an Australian state were to enact a statute excluding attorneys who reside in other states from admission to the bar of that state. This statute appears to conflict with Section 117 of the Constitution. In cases of conflict, constitutional supremacy entails that the statute must yield. It's unconstitutional and should not be enforced. Section 117 would have no point if public officials were legally permitted to enforce statutes incompatible with it. This essential difference between statutes and constitutions should not obscure the many commonalities. Constitutions must be interpreted and applied just as statutes must. Public officials in every branch of government can be called upon to interpret constitutions, although most of the literature discusses interpretation by courts. Every problem faced by interpreters of statutes is also faced by interpreters of constitutions, and then some. Many of the questions that may be asked about interpretation of statutes can be asked also about constitutions. Should constitutions be interpreted in strict accordance with their written terms, or more loosely, perhaps in light of broader social purposes? Is the true meaning of a constitution given by how readers would understand it, or by the intentions of the framers, meaning the drafters or ratifiers? Is the meaning of a constitution permanently fixed when it's ratified, or can its meaning change over time? Each of these questions can be asked prescriptively or descriptively. A descriptive question asks how interpreters actually interpret. A prescriptive question asks how they ought to interpret. Because constitutional interpretation has so much in common with statutory interpretation, understanding the latter is important to understanding the former. Unfortunately, undergraduates in the United States often study constitutional law with no background in statutory interpretation. In this lecture, I'll concentrate on issues that are distinctive to constitutional interpretation, using the U.S. Constitution to illustrate. Some of the issues discussed are unique to the United States. I'll address the federal Constitution, although each of the United States has its own constitution, to which many of the same issues apply. From now on, I'll simply refer to the U.S. Constitution as the Constitution. It differs from ordinary legislation in three ways. The first difference is content. Some of its most famous provisions are much broader and vaguer than typical legislation. Consider the following provisions. The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States. From now on, I'll refer to the U.S. Constitution simply as the Constitution. It differs from ordinary legislation in three ways. The first difference is content. Some of the most famous provisions of the Constitution are much broader and vaguer than typical legislation. Consider the following provisions. The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States. Congress shall make no law abridging the freedom of speech. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. No person shall be deprived of life, liberty, or property without due process of law. No state shall deny to any person within its jurisdiction the equal protection of the laws. These provisions contain essential terms that the Constitution leaves undefined. Which laws are necessary and proper? What is a law that abridges the freedom of speech? Which are the privileges and immunities of citizens? What constitutes due process of law and equal protection? The most interesting debates in constitutional law try to answer such questions because the constitutional text does not answer them. Scholars focus on vague provisions precisely because they're more controversial, not because they're representative of the Constitution as a whole, which they aren't. Most provisions of the Constitution are more precise than those listed above. Many are procedural or structural. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof. No person except a natural-born citizen shall be eligible to the office of the President. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race. The second difference between the Constitution and ordinary legislation is that the Constitution is more difficult to change. Revising or repealing federal law requires merely a majority vote in both houses of Congress and the signature of the President. Revising or repealing a constitutional provision, by contrast, requires an affirmative vote by 2/3 of the members of both houses of Congress or conventions called by 2/3 of the state legislatures, plus ratification by 3/4 of the state legislatures or state conventions. Because of these supermajority requirements, amendments to the Constitution are difficult to achieve and rare. The Equal Rights Amendment, which prohibits denying or abridging equality of rights on account of sex, was ratified by 35 of the 50 states as of 1979, but fell 3 states short of passing by the prescribed deadline. The third difference between the Constitution and ordinary legislation may be an effect of the second difference. Most provisions of the Constitution are much older than most legislation. Even if a majority of the public agrees that a certain provision of the Constitution is obsolete, they can't do anything about it, even if a majority of them agree on a particular reform. A minority, just 13 of 50 state legislatures, can block amendments. It's well established that the Constitution is legally superior to ordinary legislation. But someone has to interpret the Constitution and decide in each instance whether a particular law is valid under it. In the United States today, interpretations of the Constitution by federal courts have final authority, ultimately the Supreme Court of the United States. But people disagree about the correct method of interpretation. An interpretive method specifies a set of considerations for interpreters to take into account, and how much weight those considerations should receive. Some common considerations include the following: framers' intent, readers' understanding, structure, values, prudence, precedent. This list is hardly exhaustive. Each of these considerations can be understood in different ways. Let's examine some of them in more detail. Many theorists hold that constitutional interpreters should consider the intentions of the framers. But who are the framers? Obviously, different amendments were drafted and ratified in different centuries by different individuals. One must also decide whether the framers are those who drafted the provision, those who ratified it, or a combination thereof. Framers' intent can be difficult to identify because the framers didn't always share intentions with one another. Questions about intention arise even if we limit ourselves to a single framer. On a subjective account of intention, the interpretation of the original Constitution could be affected by evidence of Alexander Hamilton's private thoughts, like those found in his diary, perhaps. On an objective account, such private thoughts are irrelevant. Only Hamilton's public statements, including the text of the Constitution he signed, are valid evidence of his intentions. Ronald Dworkin draws an important distinction between semantic intention and expectation intention. Semantic intention refers to what a speaker intends to say. Expectation intention refers to the effect that she expects her words to have. In many cases, these intentions converge, but they can diverge in cases of incomplete knowledge. Suppose Marlowe orders her employee to tow all the illegally parked cars, not realizing that her husband's car is parked illegally. Marlowe does not have the expectation intention to have her husband's car towed. However, her semantic intention is to tow all illegally parked cars, which happens to include her husband's. The employee does not misunderstand Marlowe when he tows her husband's car, even if Marlowe is surprised and angry about this. We can draw the same distinction between a framer's semantic intention and his expectation intention. The Eighth Amendment says, "Excessive bail shall not be required." The framers may have expected that this language would always forbid requiring bail as high as $1 million. The net worth of the U.S. government was only $44 million in 1791. But their language simply refers to excessive bail. Their semantic intention, Dworkin would say, was to ban bail that is in fact excessive. If you agree that $1 million today is not excessive bail for the most serious crimes, then it doesn't contradict the framers' semantic intention to set bail that high. Another interpretive consideration is how a reader would understand the text. Who is the reader? It's generally accepted that the reader should be understood as a reasonable person. The main question is when the interpreter should imagine the reasonable reader to be living. Originalists ask how the text would be understood by a reasonable reader at the time of drafting or ratification. Non-originalists use a reader from a later time, typically the present. Many constitutional interpreters read the document in light of the governmental structures that it establishes. The main structural features are federalism and separation of powers. Some provisions of the Constitution, especially the original document, are naturally read as preserving the jurisdiction of states and as preventing one branch of government from encroaching on the others. Some constitutional arguments proceed from value premises that have no obvious source in intent, structure, text, or any of the other considerations I've mentioned. A proponent of marijuana legalization might begin from the premise that adults have a moral right to ingest anything they wish, if doing so poses at most minimal risk to others. A constitutional argument is value-based if it moves directly from that premise to a constitutional right to smoke marijuana, without invoking other considerations. Another kind of value argument is an argument from prudence, which prevents a reading of the Constitution that would have especially bad effects. Imagine a judge who sincerely believes that arguments of intent, text, and structure strongly support the conclusion that banning fully automatic weapons violates the Second Amendment right to bear arms. This judge might nevertheless uphold the ban, based on his prudential judgment that striking it down would result in many senseless deaths. A method of constitutional interpretation can be classified in terms of the particular combination of considerations that it takes into account. Until the 1980s, many constitutional originalists gave great weight to framers' intent. Since then, many originalists have moved in the direction of Justice Antonin Scalia, for whom the ultimate guide is a reasonable reader's understanding of the provision at the time of ratification. Framers' intent is at most evidence of how readers would have understood the language, according to Scalia. A common objection to originalism is that it's impossible to determine what readers from another century would have thought about the modern world. Would someone in 1791 have considered email to be covered by the free speech or free press clauses of the First Amendment? Critics of originalism contend that there's no answer to this question because email didn't exist in 1791. One originalist reply to this objection is that we must use our imagination. True, email didn't exist in 1791, but our question isn't, did people in 1791 think email constituted speech for constitutional purposes? The question is, would people in 1791 have thought that email constituted speech had they understood email? We can imagine traveling back in time to 1791, explaining email to a reasonable person who knows about the First Amendment, and asking her if she believes that email would constitute speech for constitutional purposes. This proposal sounds silly to the non-originalist. What if we have no confidence in our imagination? What if we can't decide what our imaginary friend in 1791 would have thought? The originalist responds that if a court can't determine with confidence what the original understanding and provision would have entailed, then the court must simply uphold the challenged legislation. This is a sensible default rule. Originalism and non-originalism are best understood as mutually exclusive positions. Any position can be classified as one or the other. Non-originalists give less weight than originalists give to the original meaning of the Constitution, whether that's understood in terms of framers' intent or an original reader's understanding. An extreme non-originalist gives original meaning no weight at all. In the 1970s and 80s, non-originalists sometimes identified themselves as proponents of a living constitution. This phrase can be understood in different ways. No one denies that the text of the Constitution changes. Article 5 provides for amendment, and the document's been amended 27 times over the years. Of course, the meaning of the Constitution changes when its text changes. But living constitutionalism entails that the meaning of the Constitution can also change in between formal amendments. How are we to identify changes in meaning that occur without changes in the text? Many living constitutionalists advocate interpreting the Constitution as a reasonable reader today would interpret it, not as a reader would have when it was ratified. In some cases, this method yields an answer. Suppose plausibly that most Americans in 1791, when the Eighth Amendment was ratified, believed that horsewhipping a shoplifter did not constitute a cruel punishment. Suppose also that 90% of Americans today believe otherwise. A living constitutionalist might claim that a provision means X today, even if it once meant not X, if 90% of contemporary readers agree that it means X. Thus, the meaning of cruel has changed such that horsewhipping a shoplifter was not cruel in 1791, but is cruel today. Some living constitutionalists take a stronger position. They claim, for instance, that it's cruel to execute someone convicted of aggravated first-degree murder. They say so despite the fact that there's no contemporary consensus against executing such convicts, and there certainly was no such consensus in 1791. Some living constitutionalists claim that the Constitution protects a woman's right to have an abortion, despite the fact that there's never been a social consensus to that effect. Living constitutionalists who take such positions are using value-based arguments. They believe that the Constitution should be understood as reflecting the values of the American people, even values that are not explicit in the text. Not every value is important enough for constitutional status, but the most important ones are. This version of living constitutionalism is sometimes called the fundamental values approach. This approach requires court to identify the fundamental values of the American people. One objection is that there's no reliable way to do this in the absence of consensus. Americans disagree about whether women have a fundamental moral right to attain an elective early abortion. Given that disagreement, what could justify the assertion that our fundamental values entail such a right? Critics suggest that non-originalists who make such assertions mistake their own values for national values. Such objections have led most non-originalists in the past 2 decades to drop the living Constitution terminology and to stop claiming that the meaning of the Constitution actually changes without its text changing, although President Barack Obama used the phrase approvingly during his presidency. A more recent version of non-originalism admits that the meaning of every provision is fixed by the text, but insists that our understanding of its meaning changes and gains accuracy over time. On this view, whether executing murderers is cruel is a moral question with a timeless objective answer. If the practice is, in fact, cruel, then it was cruel even in 1791, when few Americans thought so. The interpreter should not try to determine what Americans considered cruel in 1791. Rather, she should consult the best available arguments for and against the claim that executing murderers is cruel, and read the punishments clause in that light. This prescription recalls Dworkin's emphasis on semantic intention. Adapting his terminology, we can distinguish between semantic understanding and expectation understanding. A reasonable reader in 1791 might make the following statement. I believe that some punishments are in fact cruel, and that others are not. I also believe that hanging murderers is not cruel, but I recognize that my opinion could be mistaken. I believe that the punishment clause applies to punishments that are in fact cruel, notwithstanding my current opinion. This reader's expectation understanding of cruel diverges from his semantic understanding. Non-originalists argue that many provisions of the Constitution should be read semantically. The punishments clause does not refer to punishments that we in 1791 consider to be cruel. It simply refers to cruel punishments. Some non-originalists are dissatisfied with this approach for several reasons. First, it presupposes that there are objective answers to difficult normative questions, such as which punishments are cruel. Second, it places great faith in the ability of courts to find those answers. Judges aren't trained as moral philosophers, and even moral philosophers disagree about such questions. Is there any reason to believe that judges engage in better moral reasoning than the legislative and executive branches? Yes, there is, claim some non-originalists. Judges are generally well educated and thoughtful, especially at the federal appellate level. Federal judges are also largely insulated from political pressure and can vote their consciences without fear of reprisal. So their moral judgments are likely to be superior to those of elected officials. Nevertheless, many non-originalists remain uncomfortable with the idea of judges using unrestricted moral reasoning to resolve constitutional cases. They seek more definite guidelines for judges to follow.